So we see each year a number of cases, probably as much as 25%, where one party to the tenancy doesn't respond to the dispute. So that suggests that they've gone away, they're not interested in the deposit. We know that some tenants write them off. They may be foreign students, maybe foreign workers, they may have left the country and have no interest in the return of their deposit. We're still able to adjudicate so long as the dispute's raised within 3 months in the insurance scheme. And so long as we're satisfied that that person got the invitation to respond to the dispute. If we can be happy about that, then we can imply their consent to the adjudication. They don't have to respond to say that, and we would make an adjudication decision in the normal way. There are some other arrangements that landlords can use. So in the custodial scheme, when a landlord makes a repayment request, if there's no response from a tenant, then the law requires them to complete a statutory declaration, which we help them with. We would then try and serve that on the tenant, and if there's no response at that point, they would get what they want from the deposit. In the insurance scheme, landlords can do a slightly similar thing, but they do it themselves, which is that we recommend wait until 3 months. Time limit for bringing an adjudication has expired, and then the landlord could choose to take the money that they want from the deposit. They do it at their risk, of course, because they don't have court order or adjudication decision or agreement. So a couple of options, a little bit tactical which one you might go for, but certainly there's a number of routes to a landlord being able to get their money where they're entitled to it. So we often get asked by landlords and agents, how far do I have to go to try and get hold of a tenant who's not responding at the end of the tenancy? And it's worth reminding ourselves that the prescribed information asks for a landlord or agent to give the tenant the address or confirm with the tenant the address that they can be reached at the end of the tenancy. Not the address where they'll be living, they might not know when they pay their deposit. Address where they can be reached. So it's vitally important at the beginning of the tenancy to get that information. That's your best bet as a landlord or agent for being able to get hold of the tenant. If that's the information the tenant has provided you to say that's how you get hold of me, that's the contact details that you use. Some agents or landlords will go further. You know, they might have friends, acquaintances, relatives that they might want to make some inquiries with. But I think it's a question of degree for an agent or landlord how much further they go. I think the really good minimum is getting a contact address or email from the tenant at the outset and making sure you use that at the end of the tenancy. There's certainly a problem if that contact details for the tenant aren't included in the prescribed information. Landlord or agent runs the risk of not having complied with the legal requirements to make sure that prescribed information is complete. So our advice is to always make sure that your tenant understands what you're asking them for, not the address where they live, but an address where they can be reached. That could be an email, could be a friend, a relative, bank manager, vicar, anybody, doesn't really matter. If you do come across a situation where a tenant's not able to give you something because they don't understand or they're unwilling to provide anything, make sure that you complete that part of the prescribed information, if only to say that the tenant's been unable to provide their contact details, and get the tenant to sign that to acknowledge that that's correct. That will protect a landlord or agent from serving prescribed information which is incomplete.